Welcome to the deep dive. Today we are taking on something that, well, it often feels pretty heavy, pretty dense, estate planning.
Yeah, wills and trust. They sound complicated, maybe a bit intimidating.
Right, but forget the dusty legal jargon for a second. What we're really talking about here is control. Control over your stuff, your privacy, even who looks after your kids.
And that control is definitely worth understanding. I mean, these documents, fundamentally, they're about making sure your wishes, your legacy, it's handled exactly how you want it to be.
That's really the mission today. We've been looking through sources comparing wills and trusts, but, we're really zeroing in on something crucial, something people often miss.
Juice?
The actual legal power, the oversight that a trust beneficiary has. If you're the one meant to benefit, you're not just passively waiting. You actually have rights.
Exactly. We want to give you a clear map of how these tools work. So you walk away knowing, okay, how do I structure my own affairs, but also how are the beneficiaries, the people I want to benefit, protected? And what should they expect, even demand, from the trustee managing the money?
Okay, let's unpack this then, starting right at the beginning. What's the sort of fundamental difference between a will and a trust? They both move assets, right?
They do, yeah, but they work on totally different schedules.
Mm.
A will, think of it like a letter of instruction that only gets opened and read after you die.
Okay.
It says who gets what, handles debts, and, importantly, can name guardians for minor kids.
Got it. And a trust.
A trust is more like a container,
Mm.
a legal structure you create. You put assets into this container, and you appoint a trustee, a manager, to handle them according to your rules.
And this can happen while I'm still around?
Yes, that's a living trust. Or it can be set up by your will to activate after death, which is called a testamentary trust.
But the big reason people lean towards trusts, especially living trusts, it's probate, isn't it?
That's almost always the main driver, yeah. Probate and privacy.
Okay, walk us through that. Why is avoiding probate such a big deal?
Well, when you use a will, it has to go through the probate court process. It's mandatory.
And that means
It means time, it means court fees, attorney fees, and critically, it means it's all public.
public. Like anyone can look it up.
Anyone, your assets, your debts, who inherited what becomes public record, creditors can see it, distant relatives, nosy neighbors.
Anyone.
Okay, I see the appeal of avoiding that.
Right. And trusts, assuming they're properly funded, meaning the assets are actually in the trust they're designed specifically to bypass that whole probate process.
So faster distribution of assets, more privacy.
Generally, yes. And potentially less cost in the long run, avoiding those court and legal fees associated with probate.
But there's an upfront cost, isn't there? I mean, a simple will? Maybe you do it yourself for almost nothing, or an attorney might charge, what, $1,000? But a trust, yeah, a trust package is definitely more complex to set up. You're looking at, potentially $5,000 or more for a comprehensive plan from an attorney. It's a range, obviously.
So it's an investment up front for that privacy and control later, especially if you become incapacitated.
That's a good way to put it. It buys you efficiency and privacy down the road.
What's fascinating here, as our sources point out, is the next choice you make within trusts. Revocable versus irrevocable. It really boils down to a trade-off, doesn't it? Control versus protection.
Absolutely, that's the Kerr tension. Let's start with the revocable trust, often just called a living trust. The name says it all. It's revocable, flexible,
Meaning I can change my mind.
anytime. You, the grantor, can alter it, amend it, even dissolve it completely. You keep control over the assets, you can take them out, sell them, spend the money.
Okay, so that definitely solves the probate and privacy problem.
Mm.
And it's great for planning if you get sick because you name someone to take over managing things, right?
Yeah.
A successor trustee.
Exactly. Handles incapacity smoothly.
But what's the catch? If I keep all that control,
The catch is you get zero asset protection from creditors or lawsuits. Because you still control it, legally, it's still your property. So if you get sued, those assets in your revocable trust are fair game. And crucially, it does not avoid estate taxes. The value is still part of your taxable estate when you die.
Okay, wait. So for most people, why would I ever give up control? I mean, what kind of threat am I protecting against that's worth losing the ability to change things? That
Well,
sounds like irrevocable territory.
It is. You'd consider an irrevocable trust if you have specific serious concerns. Maybe you're in a high-risk profession and worried about lawsuits. Maybe you want to shield assets from potential long-term care costs later in life. Or maybe your estate is large enough that you're facing significant federal estate taxes.
So if I put my house, say, into an irrevocable trust, it's really gone. I can't just pull it back out if I change my mind 5 years later.
Nope. It's gone. You relinquish control permanently, and that is precisely why it offers protection. Since you no longer legally own the assets.
Creditors can't touch them.
Exactly. And they're removed from your taxable estate, potentially saving a lot in estate taxes if you're above the exemption limit.
But I remember reading something about a tax downside even then. The income generated by the trust, it gets taxed differently.
That's right. There's a potential sting there. Trust income tax rates climb much, much faster than personal income tax rates.
Why is that?
It's basically designed to discourage people from just parking income-generating assets in a trust solely to avoid personal income tax. The top federal tax bracket for trusts kicks in at a much lower income level, like just over $15,000 for 2024 compared to hundreds of thousands for individuals.
Wow, okay. So using it just to earn income isn't really the point. That makes the trade-off very clear. Speaking of taxes, though, that federal estate tax exemption, it's huge right now, isn't it?
It is. For 2025, it's set at $13.99 million per person.
$13.99 million.
Per person. And it's scheduled to go up to around $15 million in 2026.
So realistically, for the vast majority of people listening whose assets are way below that threshold, the main benefit of an irrevocable trust isn't tax savings. It's purely that creditor protection aspect.
Precisely. For most folks, the real decision usually comes down to a will versus that flexible revocable trust, primarily for avoiding probate hassle and planning for potential incapacity.
Okay, this is where I think it gets really interesting, and it's something maybe beneficiaries don't always realize. Their power. People named in a trust often just sort of wait. But they actually have significant authority over the trustee, the person managing the money.
They absolutely do, and it all stems from something called fiduciary duty.
Explain that. Fiduciary duty sounds important.
It's incredibly important. It's a legal obligation, the highest standard of care recognized by law. It basically means the trustee must act solely in the best interest of the beneficiaries.
Above their own interests.
Absolutely. They have to put the beneficiary's financial well-being first in every decision they make about the trust assets. No self-dealing, no conflicts of interest. Think of it like legal handcuffs ensuring loyalty.
Okay. Now, the sources mentioned beneficiaries kind of fall into two main types, which changes how they interact with this whole setup. Can you maybe give us an example?
Sure. Let's think about it this way. Category 1 is the beneficiaries who will eventually get full control, full ownership of the trust assets, maybe when they reach a certain age, say 30. They're the ultimate owner.
Okay.
Category 2 is different. They receive benefits like regular income payments or payments for specific things, but they don't get control over the main pot of money, the principal. The source used an example. Let's call him Sam.
Right, Sam's education fund.
Exactly. Sam's trust directed the trustee to pay only for his education. So the trustee pays tuition bills directly to the college.
Yeah.
Sam gets the benefit, the education, but he never gets his hands on the lump sum.
Which protects the money from, well, maybe Sam not being great with money.
Precisely. It protects the grantor's intent and the principal itself.
So a huge difference in structure. Now, how does either type of beneficiary keep tabs on the trustee, the person with those legal handcuffs?
They have a fundamental right to monitor what the trustee is doing. State laws define the specifics, but universally, trustees have a duty to keep beneficiaries informed.
How? Like, do they send updates?
Typically, yes. Trustees are usually required to send out annual reports, sometimes called accountings.
And what's in these reports?
They should be pretty detailed. They'll show all the assets, any income received, gains, losses, distributions made, and importantly, all the trustees' fees and expenses paid out of the trust. Full transparency.
So if you're a beneficiary and maybe a year goes by and you haven't seen anything, you shouldn't just sit there.
Absolutely not. You have the right to demand that information. If the trustee isn't providing it voluntarily, the beneficiary can go to court and petition for a formal accounting. The court can compel the trustee to produce those records.
Okay, so the power is there. What if that accounting comes back and it looks bad, like really questionable investments or fees?
Then the beneficiary has further recourse. They can take legal action. They can sue the trustee for breaching that fiduciary duty.
Breach of duty like what specifically?
Oh, things like making incredibly risky or unsuitable investments that lose money, charging excessive fees, favoring one beneficiary over another unfairly, or worse, outright self-dealing, like investing trust money into their own failing business.
And if they're found liable?
The trustee can be held personally responsible. They might have to repay the lost principal to the trust out of their own pocket.
Oh.
And potentially even pay for the income the trust should have earned if the money had been managed properly and prudently. It's serious. That accountability is the beneficiary's ultimate protection.
Now, quick questions on the flip side. Can a beneficiary ever be kicked out of a trust, or can the whole trust just be ended early?
Removing a beneficiary is actually very uncommon. It would typically require the grantor, the person who set up the trust, to have explicitly included that power in the trust document itself. Otherwise, it's generally not possible.
And ending it early?
Termination is possible, but it's not easy. Generally, all the beneficiaries have to agree, they all have to be adults and legally competent, and usually need a court order. The court has to be convinced that the original purpose of the trust, as set out by the grantor, has either been fulfilled or can no longer realistically be achieved.
Okay, so connecting this back out, trusts aren't just for passing down wealth simply. They're used for some really specific, sometimes sensitive situations too, right?
Oh, definitely. They could be incredibly tailored tools. Two really important examples that come up often are special needs trusts and charitable remainder trusts.
Let's touch on the special needs trust first. Why is that so vital for someone with disabilities?
It's crucial because if a person with disabilities receives an inheritance directly, as a lump sum, it could count as their asset and disqualify them from essential government benefits. Things like supplemental security income, SSI, or Medicaid, which have strict asset limits.
Ah, I see.
So the Special Needs Trust is designed specifically to hold those inherited funds for the benefit of the disabled person, paying for supplemental needs the government programs don't cover, without having the assets count against them for eligibility purposes.
So it provides support without causing a penalty. That's really clever planning.
It really is. And the Charitable Remainder Trust, or CRT, that's another specialized tool, mostly for tax planning and philanthropy.
How does that one work?
Basically, you set up an irrevocable trust. You or other non-charitable beneficiaries, maybe your kids, receive income from the trust for a set period, say 10 or 20 years, or for life. And then, when that period ends, whatever is left in the trust, the remainder goes to a designated charity. The big benefit for the grantor is often getting a partial income tax deduction in the year they set up and fund the trust.
Interesting. Okay, slightly different direction, but still under the planning umbrella. Disinheritance. Our sources mentioned wills allow this.
Yes, generally speaking, you can use your will to disinherit your children, even adopted ones, as long as you follow specific state requirements, often meaning you have to state it very clearly so it doesn't look like an accident.
But what about a spouse? Can you disinherit your spouse?
That's much harder, often impossible depending on the state. Most states have laws, sometimes called spousal elective shares laws, that give a surviving spouse the right to claim a certain percentage of the deceased spouse's estate, regardless of what the will says. The rules vary a lot, though, especially between common law and community property states.
That leads to another really critical point, especially nowadays, planning for unmarried couples. This includes LGBTQ plus couples who might be legally partnered but not married, or just any long-term unmarried partners.
This is probably one of the areas where planning is most critical. If you're legally married, a lot of default protections kick in. But if you're not married, state intestacy laws, the rules for when there's no rel, will almost universally favor blood relatives.
Meaning the surviving partner could get nothing.
Potentially nothing. No rights to a shared home owned solely by the deceased partner, no access to retirement accounts unless specifically named as beneficiary, no automatic guardianship rights over shared children if they aren't legally adopted by both. It could be devastating. A solid estate plan with wills, maybe trusts, healthcare directives, it's absolutely essential for unmarried couples to protect each other.
So it sounds like even if someone thinks, okay, I've put beneficiaries on my IRA, my 401k, and my bank accounts are joint, they probably still need a will, maybe even alongside a trust, a blended approach.
Oh, absolutely. That's often the smartest strategy. Even if most of your major assets avoid probate through beneficiary designations or joint ownership with right of survivorship, you almost always need a will, too.
Why? What does the will do then?
It acts as a safety net. Often it's called a pour-over will when used with a trust. It basically says, anything I forgot to put in the trust or any assets that don't have a beneficiary designation should be poured over into my trust after my death. It catches anything that might otherwise fall through the cracks and be subject to those default state intestacy laws. Plus, the will is still the primary place to nominate guardians for minor children.
Right. So wrapping this all up, what's the bottom line for you, the listener, trying to navigate all this?
I think the bottom line is recognizing the core trade-offs. Trusts offer the privacy, they bypass probate, and irrevocable trusts can provide powerful asset protection or tax benefits, but they come with complexity and cost. A will is simpler, essential for guardians, and acts as that crucial backup.
And beneficiaries aren't just bystanders.
Not at all. The law arms them with real power through that fiduciary duty placed on the trustee. They have the right to information and the right to demand accountability. Don't underestimate that.
So we've talked about the cost and complexity of trusts, and we know revocable trusts don't really offer tax advantages for estates under that huge federal limit, which leads to a final thought. For someone who has diligently used beneficiary designations on their retirement accounts, life insurance, maybe joint ownership on their home, effectively avoiding probate for their major assets, is setting up a revocable living trust with all its administrative requirements, maybe sometimes overkill. Is its main value really just managing assets during incapacity and ensuring privacy, or does the complexity outweigh the benefit for a relatively straightforward estate? That's something for you to really mull over as you consider your own situation.